Hello again. So now you have finished all your packets and you're nearing completion. So what happens after you finish all your forms? Once you complete all your forms, you have to make sure all the documents that need to be notarized are notarized. So to double check, we have provided you some checklists for each of the packets and they are italicized. So make sure those are all notarized. All the other ones that are not italicized, you do not have to notarize. So just make sure all the forms are signed and notarized by you, and those that don't need notary, that you have signed them as well. So once you have all that done, what you should do is remove all the instructions and the cover sheets. So you don't need the instructions anymore. And once you have the actual forms all completed, what you may want to do is make two sets of copies. One set of copies for you, one is for your spouse, and the original is going to be going to the clerk, so you have to hold on to the original. Make sure you have all the originals separated so you don't get it mixed up, because the clerks will review it before they accept it, and if it's not original signatures, they may not accept your file. So once you have all that done, now you're going to be double check with the clerk that you're going to be filing with. The clerk in each county requires different things, so you may want to contact them and make sure that they don't need additional information from you. However, most of them will accept all the forms that you have, so bring those to the courthouse when you are ready to file. But at this point, you're not ready to file yet, so we're going to go over that, the next step, when what to do before you file with the court. All right, so now you have all the forms, you double checked, you have all your copies, and now you're going to be getting ready to serve your spouse. What does serve mean? Remember in the beginning I told you to file a lawsuit in the state of Florida, the other party has to have notice. And notice doesn't mean you telling them you're filing for divorce. It means official notice through a process server or to a sheriff's office, and this is done through a summons. And this is very important because remember I was mentioning about jurisdiction. The court does not have jurisdiction over a person unless and until that person has been served, i.e., they have notice of the court action. And as I mentioned a couple of seconds ago, you telling them you're filing for divorce, you writing a letter you're filing for divorce is not sufficient. It has to be done officially. So the packets that we're gonna go over now is the process serving process. First off, if your party agrees, meaning they're in agreement with you regarding all the case, all the issues, and you want to just settle the divorce action, and they are willing to sign paperwork to say that they're in agreement, you're going to use packet one, which says spouse agrees. And what that includes is all the forms that the other spouse needs to complete, and they have to file that with you, so then you don't have to quote unquote serve them. That is official notice saying, hey, I know that the divorce is going through. I don't need the person to serve me. I'm signing these forms, so you don't have to serve me. But I'll go over that in a minute. Number two is if spouse disagrees. So your spouse is, I don't want the divorce. I don't care. You have to sue me in a sense. So what in that instance, what you have to do is you have to serve them. Again, you telling them is not sufficient. So you have to file official service through summons. So that will be the second packet we go through. And lastly is the third one. Let's say you don't know where your spouse is. Unfortunately, it'll take a little longer time. However, you still can get a divorce even though you don't know where your spouse is living in. Let's say they live in Florida for 6 months, and then all of a sudden they moved. You don't know where they went to. You don't have an address. Their parents don't know where they are, or you don't even know where their parents are, or relatives or friends or anyone, and you can't find them. You still have to quote unquote serve them, but there's another process that you could go through to do the service. All right, so we're going to move on and we'll go over each of the packets that we have. And if it doesn't apply to you, you could just take a pause and wait until your actual form comes up. So as I mentioned, spouse agrees. This is the first page says do it yourself, divorce checklist, and spouse agrees. Again, if the other party is willing to sign the following documents to say that they're going to agree with the divorce, then this is the packet you're going to be using. If they're not going to be signing these forms, then you could disregard this packet and not use it at all. So the first page is instructions, and the second page is the answer and waiver. And at this point, all you're going to do is, if they're willing to sign it, you could at least fill out the top for them, which includes the case style that I mentioned with your name and the other person's name. And this is their responsibility to do. And they have to sign this answer, waiver, and request of copy of final judgment. And basically what they're saying that agreeing with the divorce. I don't care what they want. I'm going to give them what they want. I just want the final judgment, which is, i.e., the final divorce decree. So as you can see, you had some forms to fill out. They also have some forms to fill out. And again, it's their responsibility, not yours. So my recommendation was give these forms to them. Tell them if you're in agreement, sign these under notary. As you can see, a lot of these forms have notary, and then give them back to you, and then you could file it together. If after a while they're not going to do it, then I would suggest you file them as if they're not in agreement, and you'll have to serve them. Again, that will take a little longer, but at least you're going to get the divorce started. Again, not again, the other party has to fill out a family law financial affidavit, which you are required to do, and it's their responsibility to fill out all the information there. And you don't have to double check their work. It's their doing this under oath, so it's their responsibility to fill out all this information that you had to fill out in the past. And this form also has to be notarized. And then the next form you have is the notice of social security number. Just like you had to say you have a social security number, they have to let them know. And this, again, is their responsibility, and they have to get notarized. And if there are children involved, they have to fill out the same form you did with the Uniform Child Custody, Jurisdiction, and Enforcement Act. This is only if you have minor children of the marriage and there's going to be issues regarding custody and visitation. So they have to fill out what they think is the right information regarding the children. Just it's almost identical. It is identical to the form that you had to fill out, but they have to fill it out as well. And they have to sign all these forms. Go fill it out and sign it and get it notarized. And that's it. Before I start this section, if they're not willing to sign it with you in a timely manner and they're just dragging it out, it's putting a hold on your divorce. So if you feel like that they're not going to sign it, you may want to do just a service. That way you're not waiting on them to file the divorce. However, if they're willing to say, look, I'll sign it, I'll go with you, I'll sign it, I'll give it to you right then and there, then you could take it and file it together. That will save you a lot of time rather than waiting on them to file your divorce. Okay. So your spouse doesn't agree with the divorce and doesn't want to sign anything. I'm going to fight you all the way. That's their attitude. I don't care what you want. I'm not agreeing with you on anything. So this is when you have to serve them through a summons, either through the sheriff's office or a private process server. And the first 2 pages are instructions, which are basically what I'm going to go over. Actually, there are 3 pages. And for you to hold on to it, just so you know that the instructions are there, but I'll briefly go over the instructions. And this is a summons of personal service on an individual. This also includes information in French and in Spanish, just in case your spouse or the person you're trying to serve is not a native English speaker. And the top is going to be same as your case style in all your other forms, so make sure you keep that in. And then it says to enter other parties' full legal name. So this is the person you want to serve. So your husband or your wife that you're seeking the divorce from, you're going to include their name and their address. And then it says, if you look at it, it says important, a lawsuit has been filed against you. You have 20 days after this summons to file a written response. And what they have to do, if they want to file a response to your petition, they have to write a letter or an answer and send it to the clerk's office. And the address that you need to include here is the clerk of court of the county that you're filing the divorce. because they have to file a written response to the court, not only to you, but to the court. Otherwise, they will not accept the phone call. It says a phone call will not protect you. So make sure you include the correct court address. And then it warns whoever that you're serving, if you do not file a written response on time, you may lose the case. It doesn't involve property, and thereafter, without further warning from the court. And if they choose to file a response, they have to send you a copy. So this is the address or name and address where you're going to put your name and your address that you're receiving the mail from. If you are under confidentiality, or your address is protected under confidentiality due to domestic violence or some type of injunction, what you could write is your name and just write confidential. And what will normally happen is, if you have to file an address with the clerk of court, that they will not release. However, they will send you a copy to the confidential address. Again, I would double check with the clerk's office to make sure that's what they do, but I know most clerks, that's what they do. And then it lists all the information about warning, and you have to notify the clerk that your address is correct. And the information that we just went over is written in Spanish and then in Creole/French next. And if you look at the bottom, it says to State of Florida, to each sheriff of the state. This is a summons. So you are not signing this. The clerk of court is going to sign it. And what they will do is put a stamp here, which makes it an official document. And that is how the court is noticing the other party, saying this is an official summons for you to respond regarding the lawsuit that has been filed. So you're not going to sign it. You're only filling out the top part, and the clerk is going to sign the next part. So what do? So once you have that filled out and you have all the paperwork, what you're going to do is take this to the clerk's office, and they will sign it, and they will give you back at least 2 copies. And what do you do with those 2 copies? That's what we're going to do next. And as I mentioned previously, we were talking about process servers. So who's the one that's going to serve it? Not you personally, because you are a part of the lawsuit, so you can't serve it. So it has to be either done through the sheriff's office or a private process server. The sheriff's office is your local county sheriff or the county where the other party is residing. And if they're out of state, you're going to have to do a little bit more work and find out which sheriff or law enforcement agency serves civil process servers in that state or that county. And in the state of Florida, you could just call the local sheriff or the county sheriff and find out where if their civil division will do summons. 99% of the time, I would say the civil division is the one that will serve. So you have that information. And private process server. Of course, a lot of you don't know that there are private process servers that are willing to do the same thing. And what they are is they are usually authorized by the state of Florida and the county that they're serving, that they're authorized to serve legal documents on other parties. And if you don't know of any process server, if you go to the clerk's office when you're filing these documents, they will provide you a list of authorized process server. Just to warn you a little bit, sometimes if you're considered indigent, the sheriff may, I say big may, waive their fee for private processor or serving the documents, especially for dissolution of marriage. So I would check with the county if they do. However, majority of them won't waive it because it's not a mandatory duty on their part. So they would usually charge anywhere from $35 to $50 or sometimes $60. So you may want to check with them because they are expecting to get paid prior to doing the work. Private process servers are also charging you to serve these documents, and those fees cannot be waived whether you're indigent or not. So check with whoever you choose private service to use how much they charge. Oftentimes they will try a couple times, 2 or 3, sometimes 4 times to try and serve them. And if it goes beyond that, they might charge you extra money, so you may want to check with them. Also, if they're traveling around and it's going to take more time, they might charge you extra too. So you may want to double check with the agency whether they what their rates are. But I would say majority of the private process servers charge equivalent to what a sheriff would charge, and it's usually a flat fee, but sometimes they might charge more. Okay, so now that I've explained the service, the method of service, we're gonna fill out this form because you have to attach it with the summons so that you're sort of giving them a direction on how to serve these documents. So the top is the same as you would in any case, in all the case. And again, who do you choose? You could choose a sheriff or private process server, and you have to write their name. And again, this is civil division. It's only the civil division that served them. So what you're doing here is you're letting them know what document to serve. So you're saying, please serve. And the documents that you need to list in this area is 4 things that are mandatory or required to be served. Although you could attach all the documents, these 4 are required to be served through a process server. The first document you have to name is number 1, petition for dissolution of marriage. That's the first. Number 2, family law financial affidavit. Number 3, certificate of mandatory disclosure. And number 4, notice of social security number. Those 4 documents must be served through a process server. So you have to list those. However, to save you some time and money, I would recommend attaching all the copies for your spouse in with the summons before you send it, so then you don't have to do 2 separate mailing. That's just save you time. If you choose not to do that and you rather mail them separately, you could do that as well. But those are actually the documents that you have to serve to the process server. So once you list all the documents, you're going to write the party's name. This is the person you're seeking the divorce from. So you have to write their full legal name, their address, and work address. So you could write where you think they're currently residing and any second address that they might have. Maybe they live with their parents. Maybe they live with their girlfriend. Maybe they live with boyfriend. Maybe they live with cousin, relative, anybody. If you have a second address, it's good to list them because they will try and serve them there. And the next section, you have to list whether they have any guns. And this is for the protection of the people trying to serve them, because they don't want to be put in a place where the person may be hostile and use weapons. So they just need to be aware. If you don't know, you could write unknown. And lastly, there's special instructions. This is to list if there's anything unique. If like someone lives in a large acreage, they live in the second house in 5-acre property, and it's really hard to describe, or in a very rural area where there's no street signs that may be visible, you could write special instructions for the process server so they could find them. And then this one you could sign, and it doesn't have to be notarized. So what do you have next? Once you get all that done, you're going to attach the process service memorandum with the summons with all your documents. And what will happen is, once that document is served by the sheriff or the process server, you will get what's called a affidavit of service or proof of service, depending on who does it. And each I guess counties name it differently. Each process server names it something different, but it's usually either called affidavit of service or proof of service. And that will be filed in the court file, as well as they will send you a copy. So once you get a copy of the proof of service, it will say on this date and time, I, sheriff's office or process server, served that other person the petition and all that document to that person on this date and time. So it will include a date and time that it's served. And that date is very important to you because that other party has 20 days from that date to file a response. So what do? So you get a document that says, I served them on May 1st. So you wait. You have to wait 20 days because they have 20 days to file an answer. In the meantime, if they do file an answer, they're supposed to send you a written copy. So you should get a copy if they filed an answer. So you wait 21 days. So on May 21st, you receive nothing and you don't know what's going on. So what I would recommend is contact the clerk of court, give them your case number, and say, I have this lawsuit or divorce, and I want to know if the other party filed an answer. and they will tell you right there, there's no written answer or there is a written answer. And if there's a written answer and you didn't get a copy, what you could do is you could go to the clerk's office. You might have to physically go there and ask for a copy because they charge you a copy. They charge you for the copies. But if there is no answer, what you're going to do is fill out this next form. This next form is motion for default. And remember in the summons it says you must file a written answer, otherwise you may lose your case. And this is basically what you're saying, that basically because the other party didn't file an answer, they lose. So what you're going to seek is motion for default. And what you'll do is you'll fill out the top as usual, and you're actually motioning the clerk of court to file a default against the other party. And what we call it is default consent by default. And what it means is that because they didn't file an answer within the time allotted, they are in effect agreeing to the divorce. So this default will be granted against the other party, and in effect they're saying, I'm not fighting you. So that's what this motion is to. So what you have to do is you have to fill out the top. You're going to say, I am seeking a default, and you're going to mail this document to the other party, which is your other spouse, with their name and the address. And then you sign this with your name and address. And what you're going to do is you're going to send this with the next form, default, just with the top filled out, to the clerk's office. And what they will do, if the default is granted, they will sign, stamp, and send a copy back to you and to the other party. And so what happens after the default is entered? So once you get the copy of the default from the clerk's office, you have to contact either the family care manager or the judge's office and see if you could get a final hearing. And what normally happens is if the other party filed a default, you may be referred to the general magistrate, or the judge may handle it him or herself. But normally I would say if you're representing yourself, the general magistrate may take care of it, and they will set you up a hearing with a date and a time. And what you do is you go to the hearing, for which they call it a final hearing. And if you go to the hearing and no one shows up, then the court will grant you the divorce without any issue. However, if you go to the final hearing and then the other party shows up, then the court may send you back to what we call mediation or other methods to try and resolve the case. And that would happen also if he or she filed a written answer. If he or she files a written answer, you're done. You don't have to file a motion for default and do any of that, because what would happen is the court will set it for either mediation or some type of status to let you know what are you disputing and see if you could resolve it without going to a final hearing. Let's say you go to mediation and you reach an agreement. That's great. Then you save some time, and the court will basically, I would say 99% of the time, will accept that agreement, ratify it, meaning it will become a part of the order, and grant you the divorce that way. However, if you can't agree, what the court would do is set it for a final hearing. And what a final hearing is, a trial. Like you would go to a trial for any other case. You have to bring evidence, you have to bring witnesses, and you have to present your case, especially if it involves child custody, visitation, property division, things like that. You have to prove your case so that you get what you're seeking to get. And that takes time and effort, so just be prepared to do that if that other party files an answer and you can't resolve it through mediation. So that's, at this point, all you can do, and move on from there. So if you know where your spouse is located, you're done. You have no more to do. I would recommend you following the procedure and making sure it's all served, and you wait for the notice of hearing. So you could skip the next section. So the next section is for those that do not know where the other spouse is, and it says location of spouse unknown. And as I mentioned when we started this section, was that if you don't know where they are, i.e. you don't have an address to serve them, and they're not willing to sign a document that says I agree with the divorce, you still have to serve them. But you would not do an official, quote, official summons, because you really don't know where they're located. So this is the forms that you would need to, quote unquote, try and locate them so you could serve them, what we do through publication. And this first 2 pages, I are instructions. And what it is what you're trying to do is try and say, court, I try to find them, but I don't know where they are. And this is what the document is. If you look at it, it looks like any other document you file with the court. It says you fill out the top as the same, and it's called an affidavit of diligent search and inquiry. And what that means is you have made an effort to find the other person, but you could not find them. And what type of effort does the court need? We will go over in the bottom of it. So what you will do is you will have to look at all the things we need to do. So you're going to fill out the top with your name, and if you look at it, it tells you where I have searched or where you have searched trying to locate the person. You don't have to do every single one of them, but you have to do some of them. Like the post office, you contact the post office and say, hey, my husband's name is John Doe. He last lived at this address. Do you have any information regarding a possible address? My wife is Mary Doe. I don't know where she lives. She lived in this address. And they will usually send you something back in writing. Unfortunately, the problem with locating getting all this information, it will take some time, because it will take a couple months, I would say, for you to make all these searches. And then you could, if you know where they worked last time, you could contact the employer and say, I'm seeking a divorce. I'm trying to locate him, but I can't find him. And if you know DMV, if you could do Google search, a lot of people do Google search, and then you know any relatives that you search for. And regulatory agencies, is if they had a power bill, phone bill, etc., etc., you could contact them by mail. But again, it will take you some time, but it is not impossible. So as long as you do some of it, 4 or 5 of it, you should be sufficient. And again, you want to prove to the court, I tried looking for him, but I couldn't find him. And that's what they want. Okay? So you do all that, and you fill this form out saying, I did this, but I still couldn't find him. What you want to do is, I could not find him. So you're going to choose one. Respondent's current residence is unknown to me. So that lets the court know, I don't know where he is. And if you do know his last address, it may have been where he was residing with his mother, brother, or you. Maybe he moved out and you never heard from him again. You could let the address. Maybe his last employment. If you don't know, you could write unknown, as long as you have something to let the judge know. So then what you're saying is, I swear that I checked. Everything I just said about searching is true, and this is going to be notarized. So you have to make sure that once you fill it out, you notarize it. And after you do that, you're going to do the next form. This is actually a duplicate of that, so it's a different type of format. So you could use that one or that one. There's 2 different forms, but it's the same form in 2 different formats. So as long as you do one of them, you're sufficient. You don't have to do both. And the next section is, this is where it's important. So once you do the diligent search, what you have to do is you have to publish the notice of action. And this is very important, because this is where you're technically giving the other party notice. Remember I mentioned summons. Summons gives them notice through the sheriff's office process server by handing it to the individual. This is what we call constructive service, meaning they are going to know because you did this. Regardless of whether they look at it or not, all you're doing is you're publicizing it so that they know that an action has been filed. And if you look at this, you're going to write the top as well. You're going to write 2 is the person and any of their last known address. And you're saying you are notified that an action of dissolution marriage has been filed. And then you're going to write your name and your address if you need it. And you have to write the clerk's address, clerk of court where you filed the lawsuit. And you're saying that I am seeking a divorce from you, so I'm noticing you. And if they want to, they could go to the clerk's office to get a copy. And once you fill that out, you're going to give it to the clerk, and what they will do is they will publish it in the courthouse. They usually have an area that they publish all the public notifications. However, if your court doesn't have it, you're going to fill out the next form, which is a generic form, but unfortunately this one you have to publish with a newspaper in the county that you filed the divorce action. So you'll fill out the top is the same, and then you're going to write notice for action for dissolution of marriage. You're going to write his or her last name that you're seeking the divorce from, their address, and you're going to say the type of case is the dissolution of marriage, and your name, your address, and fill out all the information. And then if any personal property, which you're not seeking property, so you don't have to fill that section out. And then you're just letting them know that the documents are available in the clerk of courts. And once the clerk signs this section, what you're going to have to do is you're going to have to send it to the local newspaper. I would say most of Central Florida has Orlando Sentinel or any local newspaper in the county that you filed the lawsuit. And what you contact them and say, I have a notice of action, can you publish it for 4 weeks consecutively? And what they will do is they will charge you, unfortunately. I think it costs a couple $100, so you have to be aware that you're going to have to pay for that. And what they will do is they'll publish this notice for 4 consecutive weeks, and after the 4th week, they will send you a proof of publication. It's similar to affidavit of service where it says, we published this notice for 4 weeks consecutive from this time, this time, this time. And it'll have the date and time, and it'll be signed by someone from the newspaper. When you get this notice of publication or proof of publication, that begins the 20-day time that we had to wait when we did the summons. So you have 20 days from that last date of this publication. The other party has 20 days to file an answer. So you wait 20 days. So the notice says our last day of publication was May 1st, 2019. So you wait 20 days. So May 21st, you're going to contact the clerk and say, I received a proof of publication and it said the last day was X, Y, and Z. Can you check for me if anyone's filed a written answer? And they'll let you know if there was a written answer or not. And if there's no answer, then you're going to fill out the next form, motion for default. And this is similar to the other one. So basically you're saying, clerk, please tell me that the other party hasn't filed anything, so I should be entitled to default. And again, it's like consent for default. So you fill out the top and notice, and you just write other party, and the address is unknown because you did the proof of publication. And then you sign it with your address, and then the clerk will send you a notice of the default. So once you receive that, you're going to do the same thing as the other situation where you once you get the default, you could contact either the family care manager or family case manager or case management, depending on what they call it, and or the clerk, and say, can I set it for a final hearing? Oftentimes, if you contact the clerk, they'll probably give it to the judge's judicial assistant. So, and they might go back and forth and see who's going to do the hearing. If you're representing yourself, generally the general magistrate is the one that's going to hear the case. So then you will be referred to him or her for a final hearing, and you will do the same. Wait for the hearing, go to the hearing. If the other party doesn't show up, then you will get the divorce by default. Again, if the other party shows up, then it sets it up for either having a final hearing or further proceedings. So that's what you have to wait for. And so that's all we have for now. So if you have any questions, please contact Legal Services of Mid-Florida, and hopefully you will be able to get through all the process. Again, you can do it without the assistance of an attorney and get through and have a divorce through that. Good luck to everybody, and thank you for your time. For those of you that do not know where your spouse is currently located, you're going to be filling out the next set of forms. This is for location of spouse unknown. And just as the title suggests, it's for those cases where if you don't know where your spouse is currently residing, or actually if you don't have an address to serve him through the process server, this is the packet that you will need. And as the title suggests, you have to do a research to try and locate where they are. And there are forms involving cases for dissolution of marriage with children and without children. So make sure you fill out the right form. There's two forms, one for children and one without children. So we'll go over it. There's 2 pages of instruction. So we're going to go through the first one. And they're basically, the forms are identical. However, just the title is different. So if you have no children, and no property to divide, then you will use one form, and if you do have children, you will use a different form. So now we're going to go over the form. This is an affidavit, basically like the financial affidavit. Affidavit is you're swearing to tell the truth, and that whatever you say on this form is the truth, and you'll have to get the form notarized and letting the court know that you spent time trying to locate the party. So you will fill out the top as usual, and then you're going to put your legal name, full legal name, and you're swearing that I've checked all these places. Diligent search. Diligent search means you search for him, but you couldn't find them. So what you're going to do is, as you can see, there's several areas that you could search. Post office, employment, regulatory agencies, any relatives that you may know, any telephone numbers. Maybe you could do a double check. You could go through the internet and search Google. A lot of people have done that and trying to locate them. And so you're just trying to let the court know, I've tried finding them, but I couldn't find them. In most of these cases, I would say you'd have to do it in writing because they want some type of proof. Like it says, specify detail of each search. If you're doing a Google search, you could just say, I Googled his name, this area, and I couldn't find anything. I've checked the Department of Motor Vehicles online. I couldn't find anything. In some cases, you might have to do it through a physical letter or actual letter, especially areas like the post office, regulatory agencies. You're going to have to do a letter basically saying, I'm filing a divorce. This is the person I'm seeking the divorce from. I don't have a last known address, so please check your records to see if you have any updated information. And it says check all that apply, which means you don't have to do every single one of them as long as you do some of them. If he's never been in union, it doesn't apply to you. If he hasn't worked in many years, may not apply to you. Or if they might be possibly dead, I don't know, it might not apply to you. So you're gonna do the ones that apply to you, like law enforcement arrest and criminal arrest. That may be really easy to do because a lot of these information is online. So do as much as you can, and especially if they're paying child support for another child, those are the information that you want to check and let the court know that you've done it. If you do it through letter, it will take a little longer, only because you have to receive the response back from the agency or the company. Otherwise, you can't say I've checked. And if you don't get anything back, you could let the court know, I sent out a letter, but they never sent me back anything for 2 months, 3 months, because that takes it a little longer. And so finally, what you're saying, I checked all these places, but I could not find him. So I want to let the court know I couldn't find him. So you're going to write his age right there. Or if it's unknown, you can write unknown. And this is where you're saying his current address is unknown to me, unknown to you. Not that it's unknown to anybody, but to you, and you couldn't find him. So you have to let them know. And also, where was his last address? Say last known address. It could be with maybe relatives that he or she resided with. Then you'll use that. If they resided with you the last time and then they moved out and not heard from them again, then you could use that address. If they've ever worked or they've worked in the past, you want to write wherever his or her last employer was. And if there is an address or phone number, you could let the court know about that. Just again, that's to let the court know you've made what we call diligent efforts to try and locate him. And once you do that, you're going to have this form notarized. So be prepared to do that. And the next form is identical, but it is for use for people that have minor children. So as you can see, it requires a lot of the same information, but you're going to do it for the father. It says the father. But if it's the mother, you may want to scratch it out and write the mother. And you could do all that to try and locate the same thing. You're saying, I checked the telephone, law enforcement, highway patrol. All the information is same as the areas that you would check for the first one, but this would be used if there are minor children involved in the marriage. and there's issues regarding child support and custody and visitation. And this form also has to be notarized. So once you fill out the diligent search, you're going to have to do what's called a notice of action. And again, there's two forms. There's two separate forms. One for no children or no property, meaning you're not seeking any custody visitation issues and you're not dividing property. The next form is for ones that people have children and there might be property issues, especially if there's a house to divide, equitable distribution, things like that would be the next form. These two forms will be used to provide notice to the other party. And remember earlier I said notice is through summons only in the lawsuit? There's a way that you can provide notice through constructive notice. And that's what this notice of action is. What would normally happen is you're going to fill out the information provided in this form and you will give it to the clerk of court. And I'll say majority of the clerk of courts will do what they call posting, and they have an area in the courthouse where they post these notices of action. However, if the clerk of court does not provide that posting of notices of action, you're going to have to publish it through the newspaper. Oh, what does that mean? You have to find a local newspaper where you filed the lawsuit, and you're going to have to send them this notice of action, and they will have to publish it for 4 consecutive weeks. And what they do is they publish it in the legal notices section of the newspaper for 4 consecutive weeks, and on the last day of their posting, they will send you what's called a proof of publication to let you know that they've published for 4 weeks. So if you've done it through the clerk of courts and they posted it, they will send you a letter saying that we posted it for 4 weeks. And if you do it through the newspaper will let you know through a proof of publication that they've published for 4 weeks. Once you get that back, we're going to go to the next step. So we're going to go over the form, and it's a notice of action like the top is the same as you would file in any other document. And then you're going to write the respondent as the person that you know. And if you know their last address, you could write their last address. And again, you're saying that the dissolution of marriage has been filed, and then they have to send you a copy of any information or written answers, things like that. So you're going to have to write your name and your address, and you want to write a date. I would recommend giving them 1 month, so that that's 4 consecutive weeks, so that they could have time to file an answer. And then you're going to have to write the clerk's address there. So they will file the written answer like you did with the summons. That's where they will file the answer. And if you're seeking to divide property, you would have to write this. In this instance, however, because this is a divorce action, I will write none because you're not seeking anything in this. So this is just to let them know that they have to contact the clerk if they're going to file an answer, if they see this. And this form will be filled out, and the clerk is going to sign it and either give you a copy and retain the original, or give you the original and retain a copy. If they're going to post it, they'll keep the original. If they're going to send it to you to publish it through the newspaper, they'll give you the original. So that's how it works. And the second form is for those with children, and it's about the same. Again, it has the same information regarding the type of case, and you're going to be, this notified action is for dissolution of marriage. So the top will be the same, your name, his or her name, and the dissolution of marriage, and you have to write your name with your address. And if you look at the bottom, again, the clerk is going to sign this form and either send you the original to publish, or they're going to post it. So what would happen? So once it's published for 4 consecutive weeks, you will receive the proof of publication. Once you receive that, the other party has 20 days to file a written response. Just like if they were summoned through a summons, they would have to have 20 days to respond. After the 20 days from the date of publication, last date of publication, you could contact the clerk and or the family case manager, whoever is handling the case, and say, hey, this is my case number. I want to know if anyone's filed a written response. If it's been the 4 weeks and it has been a certain amount of time, they'll let you know. If it isn't, they'll be like, no, you have to wait another week because we've only published for 2-3 weeks, and they'll let you know. So let's say it's been 4 weeks, and then you've waited 20 days, and no one's filed a response, then you could file this motion for default. And motion for default is basically seeking the divorce through consent. So they call it a consent by default. Because they didn't file an answer, they're in effect agreeing to the divorce. So you're motioning the court saying, court, because they didn't file an answer, I should get what I want, or the divorce should be granted in my favor. So you fill out the top, and you're going to mail a copy to the other party, and you're going to sign and write your address, and you're going to send it to the clerk with the next form. And the next form is the default form. And you fill out the top, and the clerk will stamp and seal the next page. And what that does is basically the clerk is saying the default has been granted because the other party hasn't filed an answer. And what you do with this default is once you get it, they will file it in the court file. So what you want to do is contact the judicial assistant and or the family case manager, or sometimes you could contact the clerk as well, and they might be able to help you. Say, I got a default, I would like to set it for a final hearing. And then they'll contact you or tell you over the phone a date and time to have the hearing. And then you go to that hearing. Once you go to that hearing, you wait and see if the other party shows up. If they do appear at the hearing, then the court will do like it would do in the other cases where they may set it for mediation or continue a hearing and set it for another status to make sure that there's no dispute. If they show up and say, oh, I want the divorce, they may resolve it right then and there. If not, they may send it back to mediation. So if they don't show up, then the court should grant you the final judgment. So make sure you go to any type of hearing that the court sets for you. So if you go to the hearing and they say the divorce will be granted, we will issue the final judgment, you are done. And you have to wait for the final judgment, and there's a 30-day wait period for before you could do anything else, get married, etc., because there's a 30-day appeals period if there's any issue that the other party wants to fight and say the court didn't do right. Otherwise, you're done, and you should be able to get divorced and move on. If you have any questions, you can contact the Community Legal Services, and they should be able to provide you some more guidance. Otherwise, good luck with your divorce, and I'm sure you'll be able to do it on your own. Thank you.